This is the American Law Journal.
The most common workers' comp claim, back injury. The most common prescription, opioid drugs, are painkillers and an outdated system killing workers' comp. Good evening. I'm Christopher Naughton. This is the American Law Journal. Opioid drug use and its costs are skyrocketing. How do you spell relief for a workers' comp system that may very well be leaving its injured workers behind? ALM's Gina Passarella has this.
I never meant to cause you any sorrow. I never meant to cause you any pain.
Pain. When Americans experience it, more and more they're being prescribed opioid drugs, such as fentanyl. But now, many are becoming addicted, or worse, like Prince, dying.
On this opioids issue, this is an area where the incidence of people dying from overdoses is actually spiking.
And nowhere has that pain been felt more acutely than by those hurt on the job.
But they get into these situations where they're injured and they go to a doctor and they get on these prescription drugs, and I can't tell you how high the percentage is of when we're trying to settle a case, we can't cut off their medical because they are scared out of their mind to not have these pills anymore.
The biggest trend I'm seeing is the wreckage of lives with overprescription of opiates. When you see someone going in for a back strain and they're getting a 30-day supply of Percocet, I think that's just wrong.
That's why there is a movement in many states, including Pennsylvania, to change the laws, to require all medical care for injured workers be consistent with nationally recognized evidence-based medical treatment guidelines. The hope is it will cut opioid casualties and lower corporate and insurance company costs. It's that last part that makes claimants' attorneys skeptical.
So House Bill 1800 is a bad thing. It's bad for doctors and it's bad for injured workers because the standard is not what a cookie cutter model holds for your healing based on your injury. That's a decision between you and your doctor and his or her expertise and experience.
Another growing concern, studies that portray state workers' comp systems as out of touch, failing injured workers, where businesses keep cutting comp benefits to pad their bottom line.
The Department of Labor did a report recently, and what they found was that in a lot of states they've enacted laws that have sort of shifted the cost away from the employer when an employee gets injured, and now that cost is being borne more by the workers themselves and the taxpayers.
Recent NPR and ProPublica investigations cite Tyson Food Company of using financial influence and political muscle to cut its comp costs. After Iowa's Workers' Comp Commissioner Chris Godfrey issued decisions against Tyson, Iowa's new governor Terry Branstad, supported by Tyson in the election, demanded Godfrey's resignation. Since he could not fire the commissioner, he slashed his salary by 30%.
A lot of these big employers are very powerful lobbyists, so they've been able to sort of lobby their local governments, their state governments to shift these costs.
That's why some, including the Department of Labor, are calling for federal oversight to ensure states protect injured workers. But it's a tough question.
I defend companies whose workers are injured. My clients who are in more than one state would love to see a federal standard because think of the expense to them to train and have quality control for 50 different workers' compensation laws. But do you force every other state to be under federal jurisdiction, or do you leave it to the unions and the workers and the businesses in those individual states to work out another grand bargain unique to that state's issues?
The Department of Labor's conclusion is clear. The workers' comp system is outdated, and states are falling behind in protecting injured workers. But not everyone sees a federal solution as a positive, and in all likelihood, the new Trump administration would agree. For the American Law Journal, I'm Gina Passarella.
All right, 4 guests with me tonight. A 5th will join us in just a minute or two. Lori Carroll returns to the program with Nolte Scarcamaza and McDevitt. Her clients include hospitals and insurance carriers, self-insureds, and third-party administrators. George Beatty has spent over 30 years defending the rights of the injured, especially those hurt at work. Plaintiff's attorney with Beatty, Sloan, and DeGeneva. The Honorable Joseph Haken joins us once again. He has been sharing his comp insights with us for almost 15 years. And Matt Matt Wynn also returns to our program. He has more than 25 years of experience representing employers, insurance companies, and third-party administration in comp matters. I hear this from almost every workers' compensation attorney I talk to. And it doesn't matter if it's a respondent's attorney, a defense attorney, or a claimant's attorney. And that opioid drug use and drug addiction is rampant in the comp system.
Well, I think it is. It's so rampant in the comp system and out of the comp system. And as far as my clients are concerned, it costs a lot of money. They're spending $2,000 to $3,000 a month on opioid medication. And it really does need to be reined in.
I think the opioid drug problem is something that's widespread. It's not limited to the workers' comp system. I think it's a societal problem, and I think it's reprehensible that the insurance industry and their lobbyists are trying to use this opioid issue as a way of gouging the rights of workers, because there's nothing different about an injured worker than an injured citizen. And the fact that there's an opioid problem is a problem that faces society as a whole.
Yeah, but George, do you think that the doctors who have been treating injured workers have overprescribed opioid drugs now over the last 10 years?
I don't think it's any different between workers' compensation claimants that are injured and other people that are injured. I don't think there should be two systems set up. I don't think that injured workers should be treated as second-class citizens. Now, that doesn't mean I don't think there's a problem with the opioid medication, but I think it's a problem that we face as a society at large. And I don't think we should allow this issue to be used as a wedge or as a lever to scale back the protections for injured workers. They shouldn't be treated like second-class citizens. They should have the same treatment rights, the same options that any other injured person would have. And I think it's wrong that they're trying to use this as a way of further curtailing workers' rights.
Hey, Matt, would you say that back injuries are indeed probably the most common of all injuries, and maybe that's the genesis of some of this drug problem we're seeing in the comp system and elsewhere? It seems like it is. It's probably, I would say maybe 50% of my cases involve back injury and back pain. A lot of times the opioid medications are prescribed from the get-go by physicians, and unfortunately they can become really addictive within just a couple of weeks or a couple of months. I think it's a problem that both the claimants as people face, because they're the ones who get addicted, and also the insurance companies who end up paying for those medications. Unfortunately, sometimes doctors have it in their own best interest to prescribe them for whatever reasons they may have their own pecuniary interest in prescribing those drugs. And I know, Lori, that a lot of those on the insurance side of the ledger believe that a lot of these drugs are coming out of the doctors' offices themselves, the treating doctors, that they're not going to, let's say, a pharmacy to get those drugs. They're actually purchasing them or getting them at doctors' offices. And I've heard, again, respondents' attorneys, defense attorneys say that's a problem.
Right, I think that's very troubling because the doctor has a medical incentive or financial incentive in prescribing these medications. And so it makes it very difficult for the employer because they are just left to pay for these exorbitant amount of money for opioid medications.
Let's bring in Alex Halper, who is now the Director of Business and Industry Affairs for Pennsylvania's Chamber of Commerce. Alex, good evening. Thanks for joining us tonight. I understand that you and your group, the Chamber, is really behind a new bill that they'd like to get passed in the state, which deals with medical care guidelines. I'm sure there's going to be a diversity of opinion here. Tell us a little bit about it and why you're trying to get that bill passed.
Sure. This is something that has become much more standard, very common in states around the country. These are guidelines based on evidence with a full range of different treatment. When someone gets hurt on the job, everyone's goal should be that individual getting completely healthy, back to full function, and back to full wages, back to their job. And we've seen Johns Hopkins had a study that shows when evidence-based medical treatment guidelines in states where those are utilized, it results in better outcomes for patients. So we believe that this makes sense for Pennsylvania. If the goal is to get injured workers back to full function, back to full health, and back to work, then this makes sense here in Pennsylvania as well.
Part of the criticism has been about this prospective bill is that it takes the power out of the hands of doctors, that it's one size fits all, and doctors are not going to have the kind of leeway that they've had in the past, because maybe we don't trust them.
that is not reflective at all of the reality we've seen in other states. There is a standard conventional medicine and treatment guidelines, and this is not just for workers' comp, this is in all healthcare, that's utilized when someone gets injured. And there's no reason why an injured worker ought to be treated differently than anyone else who gets injured that's covered by any other type of health care.
We totally agree.
And I appreciate that. I think, I hope we can work together to advance this because, again, it's about the best interest of the patient, and we have the experience of other states where this has been beneficial, and there's no reason why it wouldn't be helpful in Pennsylvania as well.
It's really not in the best interest of the patient. And when I said that, I said I agree with you that our goal is to get people back to work, and our goal is to treat them like everyone else. But what this law does, which is pushed by the Chamber of Commerce, by the insurance industry, by the lobbyists for big business, is to try to make injured workers second-class citizens. And they're not treated like everybody else. Everybody else can go to a doctor and get that doctor's best advice, best treatment, tailored specifically for that person's injury, that person's condition. But what they want to do in this law is to make every injured worker treated as a second-class citizen. They're only allowed to get this treatment or that treatment, decided by a panel of politically appointed doctors. So the politicians will appoint a panel of doctors that they control, and that panel of doctors will say, the only treatment that's allowed for this kind of injury is A, B, or C. Taking away the doctor's discretion, taking away the rights of an injured worker, making the injured worker less than anybody else who's injured. I think it's just wrong. And of course you don't agree because this is all about making it cheaper so insurance companies can make more money.
I would encourage you to read a recent report out of the Johns Hopkins University that showed better outcomes for patients when treatment guidelines are utilized.
So
and again, this is not prescriptive medicine. Any healthcare professional will tell you that for a particular injury, there are treatments and a range of treatments that are considered evidence-based, and experience has shown that they are effective. And under this type of framework, if a physician believes that a patient is unique and needs treatment that falls outside of what conventional medicine would say is appropriate, then there's a process of obtaining a waiver. But yeah, I think we both agree in the sense that an injured worker is similar, if not the same, to just a citizen who gets injured and is covered by regular group health.
Alex,
we're talking about the same. We're talking about the same health care.
Alex, give me an example of what you mean by standardized guidelines, because those are just words right now. Give me an illustration of what an injured worker will be faced with now if this bill passes.
You mentioned back injuries or strained backs are very common with workers' comp, and that's very true. You may have, and this is just an example, you may have treatment guidelines that say this type of a back strain with this level of severity, of this seriousness, with this body type, we would expect there to be between 5 and 25 physical therapy visits during the course of the treatment. So that is automatically covered. The benefit to the healthcare provider is they don't have to question whether it's going to be approved or whether there's going to be an objection to it. That's already covered. And if they believe that for some reason their patient is unique and requires treatment beyond the high end of the range that evidence and experience shows is necessary, then they can apply for a waiver.
How difficult is that threshold going to be to show that they can kind of get outside the system?
That's the beauty of this system, is that all the rules are laid out. The problem right now is we have a system that says, we have a law that says if it's reasonable and necessary, then it gets covered, and then lawyers just end up fighting it out what reasonable and necessary means, and that's why Pennsylvania is one of the most litigious states in the country when it comes to workers' comp. We just need some rules of the game. It shouldn't benefit one side or the other. The evidence and physicians and doctors should be demonstrating what the rules are.
Well, you should also know that
I'm sorry, Christopher.
Go ahead, Jerry.
I just can't disagree more. Since 2012, the lost cost filings, those are the things that insurance companies put up there and showing if they're making money or losing money or which way their premium should go. Since 2012, every year, those numbers have gone down. The insurance companies are doing better. The costs are going lower each year for the last 4 years. And that system's not broken.
Employers have been investing a lot in workplace safety, and it is a blessing that we're having so many fewer workplace accidents that are bringing those costs low. But if you're that one employer, if you're that small business that has one that has a case where the costs just start to skyrocket and the wrong people get involved, then that employer is not seeing their premiums go down. They're probably seeing a huge premium spike.
Alex, I think you just highlighted the issue right there. You said that employer, if that employer sees this. No, it's insurance companies. The employers have to be insured under state law. What about that injured worker? That injured worker is now going to be treated differently than his neighbor who got an injury not at work. The neighbor who got an injury not at work can get therapy. He may need acupuncture. He may need chiropractic. He may need something different. I've been doing this for 34 years, and I've seen all kinds of variation in the needs of my clients and the patients. And for you to suggest that it's a good thing to make workers be second-class citizens and have to get only certain specified treatment determined by a panel of politically appointed doctors who are put there by the insurance industry to save the insurance industry money is just reprehensible.
Let me get Lori Carroll in here. We'll get back to you, gentlemen. Go ahead, Lori.
Well, of course, I'm going to agree with Alex. Reasonable and necessary treatment, that's not a legal issue. That's a medical issue. We've turned it into a legal issue. And once, when the law changed, I thought that it would be a medical issue, that you had an impartial doctor looking at a person's treatment, deciding what was reasonable and necessary.
Yes.
And it was working for a minute, and then that decision is appealed. Then it goes to judges, someone like Judge Haken, who has to determine what's reasonable and what's necessary. How does he go about doing that? How does he do it? Because now I'm litigating, I don't know, I'm not a doctor, but now I'm litigating what's reasonable and necessary when an impartial physician just told me what was reasonable and necessary. And why do you need to litigate that? I agree.
Physician, and that's the problem, Lori. They're not impartial. They're appointed. They're politically appointed. These doctors are going to be appointed on a panel, and they're going to serve a 6-year term according to this proposed legislation. And who knows who gets on this panel? I want to be able to tell my client, you go to your doctor, and if the treatment is reasonable and necessary, then it gets covered. And we have people like Judge Haken who will be able to say, is this reasonable or necessary? You're entitled to your due process. You're entitled to your treatment. And it's not taken away into a cookie cutter, one size fits all. It's just not fair to save money. And the system's not even broken. They're spending less money over the last 4 years. I know it's happened in other states, but I think you need to follow the money.
I think most doctors, I don't want to cut anybody off, but I think most doctors worth their weight are impartial. There are set standards of treatment, and those doctors want to make sure that those set standards are covered. You have doctors, not the ones who profit off of a person's misery and keep prescribing drugs and that doctor keeps prescribing physical therapy. Not that doctor that profits off of someone's misery, but a doctor who is really concentrated on restoring that person back to their pre-injury position. Those doctors can be on the panel,
right now,
and those doctors would know what reasonable and necessary treatment is and what those standards are.
I would like to ask Judge Haken, if Judge Haken sees a doctor who is, as you say, Lori, profiting from someone's misery, Judge Haken is going to say, no, that is not reasonable treatment. It's not necessary treatment.
And I was trying to keep Judge Haken out of the politics as much as possible, and I think there's some daylight here. So go ahead, Judge.
And I want to stay out of the controversy that really surrounds this area. All I can talk to, frankly, is the system as we have it. The judge's responsibility is to be impartial, to hear the evidence and come to a just decision to the best they can, or she can. Now, the current system, whether on any drug, if a claimant is taking some sort of prescription medication or any other kind of treatment, if in fact it's deemed expected that it's not reasonable or necessary, that is the standard, the party can go to utilization review, in which the opinion of the utilization review doctor or provider, whoever it might be, comes into evidence as a matter of law, and the parties are free to present any other kind of evidence they want to present, and the judge then determines as a whole whether or not the treatment is reasonable and necessary.
But Judge, it sounds like, and again, forgive me, Alex, if I use this term, but it sounds like standardized guidelines of sorts. There are a couple of exceptions, but you're trying to standardize the system. So in some ways, what comes to the bench now is going to be a little bit different.
Yeah, I would expect it would be. Whether or not it's better or not, though, is not for me to determine. I have no opinion in regard to that.
I think it's important to realize that they're not only trying to take away the doctor's ability to decide what's right for his or her patient, which is important. There's a physician-patient relationship between the injured worker and the doctor. This legislation would basically take that away from the doctor and say, you have to do this. It also takes away from the judge. What Judge Haken just described was a system that's been in place for over 20 years that works, that each person that's getting treatment, if the treatment isn't being effective, if a doctor's profiting under misery, then the insurance company could come in and say, you're not treating this person reasonably, it's not necessary. They could go litigate the issue. Judge Haken is there for that purpose. So they're taking away not only the doctor's discretion, they're going to tell the judges how they have to decide the case. This is unconscionable.
I don't see
and if you look at the background, I think it's important to realize what's behind this. You need to follow the money. So when you look at who donates to the Republican candidates for state legislature and state senate, the people who are pushing this, the insurance industry and Chamber of Commerce people donate large amounts of money to the Republican campaigns. They come in, they try to pass legislation like this that would cut off injured workers' rights. Just follow the money.
I think we've got some red herrings. I'm not sure, and I say with all due respect, I don't see how you can say that two lawyers and a judge arguing about what constitutes good medicine makes more sense than a system in which the evidence from medical professionals and the experience all over the country and the millions of different back strains that have been experienced in our country over the years and being able to show what range of treatment is acceptable is not the more logical approach.
Matt, let me get you in here because I would have to say again, you're defense counsel, respondents counsel in workers' compensation. Isn't it legitimate to say that a lot of what we are facing here is because of the drug use, the opioid drug use that is being prescribed to people in the comp system, and maybe costs have gotten out of hand? Don't you think that this is a driving force behind this legislation, and maybe that's fair?
I think it's the opioid drug use. I think it's the endless physical therapy, the endless chiropractic treatment. To your viewers out there, if you're not a workers' comp claimant, you may not even know what we're talking about because most private insurance has limits on how many visits you can get to the chiropractor, how many times you can go for physical therapy, and what drugs you can get. It's only in workers' compensation where those benefits are endless unless the insurance company finally takes up the proactive position and files a utilization review, which takes months to be resolved. In the meantime, claimants are getting chiropractic care, physical therapy 3 or 4 times a week for months on end, much more than you would ever get in the private system. And I think what Alex is talking about is just going to kind of bring workers' comp system in line with what really exists already in the private insurance.
I mean, it's not broken. It doesn't need to be fixed because what Matt just described is a situation when one claimant gets out of hand, and let's say a doctor is over-treating. There is a remedy. There's a utilization review process that works, and the person gets due process. There's not predetermined cookie-cutter, one-size-fits-all methods. What happens here is the insurance company says, hey, you're over-treating. They file a utilization review. If it goes to Judge Haken, he has to decide it. Yeah, is it reasonable or necessary? So if the system's not broken, don't fix it.
It is broken because the UR system only examines one provider. You can just switch to a different chiropractor in the same office and treat with him. And when I file a UR against that chiropractor, you switch to another one. It's kind of a game. You keep on treating until this case settles, and then magically the claimant is cured and the treatment stops.
I have to say goodnight to Alex Halper at this point. Alex, again, with the Pennsylvania Chamber of Commerce, and it's HB 1800, correct, Alex?
That's what it was in the previous session, and we're expecting it to get reintroduced this coming January.
Okay, and then prospectively, again, these things can sit around for a while, can they not?
They have, but we have, I think, some momentum here. We have a broad coalition who are interested in bringing a little bit of structure to this workers' comp system. We're clearly dealing with a little bit of misinformation out there, maybe some misunderstanding about what this legislation is actually intended to do and what the impact would be, but I'm cautiously optimistic.
Thank you for joining us tonight. I appreciate you being here.
Thank you.
Lori, you probably don't agree that states are falling behind in protecting injured workers, and yet all the statistics, and you were on a program last year, we talked about ProPublica and NPR, and they talked about some of the, and Pennsylvania is almost at the bottom. It's like 43 out of 50 states that there is a decrease in benefits for injured workers. Those are not my statistics. That's DOL, NPR, and ProPublica.
I've always been a firm believer in balance. There's a cost of doing business in Pennsylvania. Employers look at those costs, the high cost of workers' comp or taxes or health care. All of those are in the basket when an employer thinks about cost of doing business. You have to keep the cost low in Pennsylvania to have employers want to do business in Pennsylvania. And I do not think, like I said before, in Pennsylvania, it used to be very claimant-oriented. I think right now we are becoming more of a balanced system that helps both the employee but helps with the employer try to control cost. So that employer will stay doing business in Pennsylvania, and that employer will have the insurance, the workers' comp insurance, to help other injured employees.
Let's move on to some other topics that may be a little less politically charged, although maybe not. Matt, what about IMEs? What's happening in your practice regarding independent medical exams?
Well, independent medical examinations occur whenever a claimant has been on workers' compensation for a period of time. They're now no longer treating with the panel physicians, the so-called company doctors, and the employer or the insurance company needs to determine what the status is. Has the claimant fully recovered? Or if not, what kind of work can they do? We need to have the patient examined by an independent physician to see if the opinions of their doctors are the same as what the independent physician comes up with. IMEs can be done twice a year generally, and all my clients really utilize them mostly to try to get somebody back to work. If the IME doctor says they're fully recovered, we offer them their full duty job back. If they can only do light duty, we try to find something that's within their physical capabilities. And what happens in these cases, if the claimant does not return to a job that they are found capable of doing, their benefits can be suspended. So that's what we use them for. That's an expensive part of our practice. The IMEs are expensive. If it goes to litigation, the depositions of the experts are expensive. But if it comes down to it, that's pretty much how it works in Pennsylvania.
I hate to sound cynical, and I agree with Matt. It is an expensive part of the litigation for the insurance companies because they're really not independent medical exams. They're defense medical exams. They're not an IME, they're a DME. If an insurance company is going to pick a doctor to examine an injured worker, they're not going to go pick an honest, impartial, independent doctor. They're going to pick a doctor that's going to say what they want them to say. So if the doctor says too often, oh wow, this guy's hurt really bad, he should stay on workers' comp, he's not able to work, they're going to get rid of him. They're going to hire the doctor that says what they want. And Matt's right, it is very expensive for them. They have to pay this doctor thousands of dollars to give these opinions, take his testimony, and hope that the judge buys it. Now, you know, we see all kinds of DME doctors. Some are more credible than others. And Judge Haken sees them all. He sees it all. And sometimes he'll see the same doctor again and again and again for the insurance company. And I think that there's some issues about credibility. And it is a very expensive part of the system. And that's unfortunate.
Oh, I think George is right. A doctor that's used too much, who seems to give the opinion that the insurance company wants every time, will not be believed. And his opinion is useless. I'm not going to pay several $100s to have somebody examined by a physician that no judge will believe. So we're always on the lookout to find different doctors to try out. We try to tailor it to the specific kind of injury. We want the specific kind of specialist who's going to issue a credible opinion. And I'm sure if Judge Haken sees the same doctor in 4 cases in a row, he's going to figure out that that's just a popular doctor because he gives the opinion that the insurance company wants. It's not what we want.
Judge, we haven't put you in a political box tonight, have we?
I hope not. Let me repeat, I cannot get involved in any controversy.
And I want to thank Judge Haken for joining us tonight again, because we knew that some of this was going to be politically tinged, but we kept you out of the fray as much as we could. Yes, it's true. Some people do take advantage of workers' compensation, bogus injuries, malingering. But what happens when the boss or the insurance company refuses to play fair? Good evening. Welcome to the program. I'm Christopher Naughton. What do you think is worse, a person who fakes a work injury and stays on comp for years, or a boss who refuses to pay benefits to an injured worker who tumbled in a concrete pit to save a dying man's life? Gina Passarella with the Legal Intelligencer has this.
As much as you need to.
Gotcha.
Okay.
Okay.
And don't worry about that. Workers' comp. No, workers' comp will take care of all that.
Gotcha.
So you'll be all right with that. But this way you can get started right away.
For as long as there's been workers' comp, there's been fraud.
faking injuries, malingering, even teaming up with dishonest lawyers and doctors to milk an injury.
I think if you speak to some of my clients, they'll say it's a big problem. I think it's a mixed bag.
I think that claimants get a bad rap, quite frankly. It's more of a myth than anything else.
But just go to YouTube or Google workers' comp fraud and you will see hundreds of examples. But is that telling the whole story?
The most blatant kind would be where an injury is totally fabricated. And that does happen occasionally. 3 or 4 cases I get a year, the employer says we need to contest this claim. But I would say I think it's a rare case where you have an outright fabricated injury.
And studies bear that out. Only 1 to 2% of workers' comp claims are fraudulent.
Where you get into a gray area is if you are claiming that you're totally disabled and then perhaps they send a private investigator out and you're at the playground down the street with your 2-year-old. Oh, well, that must be fraud because, you know, they're supposed to be bedridden. Well, nobody says that. I'm sure, I don't even think the injured worker would claim to be bedridden. So simply because the individual is out doesn't mean that there's fraud involved.
More often than not, I think you have the kind of case where it's just kind of extending care and extending treatment. Then we kind of feel like that's kind of a malingering situation or an exaggeration of a claim. Not as serious and much more common.
And sometimes it's not just the worker who demonstrates comp fraud or lack of good faith. It's the employer. One case upsetting pro-worker groups is about a man who went into a sanitation plant's methane pit to save another worker who had fallen in. The first worker died. The Good Samaritan survived, but was badly injured. He filed for comp. But the employer refused, saying the man was not acting in furtherance of the employer's business interests, and his act as a Good Samaritan was not employment-related. That case is now before the PA Supreme Court.
The basic tenet of the Workers' Compensation Act is that this is a humanitarian act. And when you start interpreting rules technically and in favor of the employer or against the injured worker's rights, you're no longer interpreting this as a humanitarian act.
Is workers' comp fraud a problem? It depends on which camp you ask. Insurance carriers would certainly say so. They cite to billions of dollars a year paid out for workers' comp fraud. But claimants and injured workers support groups say reports of bogus claims and malingering are overblown. Like voter fraud or disability fraud, there's no there. For the American Law Journal, I'm Gina Passarella.
All right, 4 guests with me tonight, 2 lawyers, an investigator, and a comp judge. Let's go ahead and meet them. George Beatty has been a champion of injured people and workers' rights now for over 30 years with the law firm of Beatty, Sloan, and DeGeneva. The Honorable Todd Seelig joins us once again, Pennsylvania workers' compensation judge, and in his spare time, he's an adjunct professor at Villanova Law. Lori Carroll, never at a loss for words for herself, a corporate defense attorney, respondents counsel in workers' compensation with Nolte, Scaracamaza, and McDevitt. And Joe Gill returns to the program. He and his firm, Gill & Associates, conduct private investigations, including workers' comp fraud investigations. 1-800-426-4625, the number right here in the studio. If you're bashful, write to us at info@lawjournaltv.com. If you don't, get in touch with us early. We can't answer your question. Let me go, before we get to some video of workers committing fraud, because we know we'll get to that tonight, I've got to go to this pipeline systems case, which is going before the Supreme Court. And again, we've got a situation where a man is hired by a company to go to a sanitation plant in Western PA. He sees a man fall into a concrete pit. He goes into the pit after him, finds out that the man is dead. He gets to the bottom. Methane gas overtakes him. He falls himself, and he doesn't die. He's injured. Comes out, he wants workers' compensation. And the employer says, no, I'm incredulous.
Who's going to start, George?
Well, incredulous is a kind word, Christopher. I mean, what happened here is, demonstrative of what these employers and these insurance companies do. It's all about the almighty dollar. The judge, the appeal board, and the Commonwealth Court have all said what this man did was in the course and scope of his job. He was on duty.
But it's going up to the Supreme Court?
I know. So this employer or the insurance company, whoever the case may be, they're so greedy and angry that they're actually going to take this up to the Supreme Court. I'm appalled by it.
Chris, let me tell you, I just think This is a public relations nightmare for the employer because we love our Good Samaritans here in America. I mean, they're the people that are on Oprah and on Ellen. And so we want people to be able to go and rescue people and help people.
I understand, but here's what the employer attorney said for the pipeline systems and for the insurance company, that the Compensation Act should not apply here to an untrained employee who is not a first responder and who is injured after abandoning his employment to engage in unsanctioned Good Samaritan activities. I'd be embarrassed to take that case, quite frankly.
Actually, there was a change in the statute. In 2003, the law was amended to specifically permit this kind of thing to be covered. So it's even more favorable for the employee.
Right.
So the guy is faced with a situation, an emergency, where somebody falls down into this pit and he goes into action to try to help a fellow human being on the same job site. He's on the job, on duty when this happens. How dare they try to make a case out of this and deny this man his life-sustaining benefits?
This would be a tough case for you to take.
I think it would be a tough case for me, and I would want to know, in this case, who actually denied the employee. Was it the claims manager, or was it the employer itself? And I was talking to the judge. I think there needs to be some boundaries on how the Good Samaritan law applies, because we don't want somebody to jump off a cliff to have the cliff to save an employee who could be hanging off the cliff. So there are boundaries that this Good Samaritan law should apply, but I think in this case, I would find it hard.
This is exactly what Joe Huddeman was talking about in the package, that if you go down this path, all of a sudden, workers' compensation looks like it's losing its humanity.
Well, that's the whole point of workers' comp, the law itself. In 1915, what they did, they took away a worker's right to sue his employer or her employer. Took away that right constitutionally. And now your only remedy is workers' comp. So you can't get pain and suffering. In a third-party action you can. You can only get your wages and your medical bills and certain other specified benefits. So they took away rights, and they gave you these rights, and they specifically said, this is a humanitarian and remedial piece of legislation that is designed to benefit the injured worker. So if you have a situation like this where somebody reacts as a Good Samaritan, tries to save another person's life on that job site, it's covered.
I don't see the Supreme Court changing what's happened in the lower courts. I mean, eventually the courts did give this man workers' compensation benefits, so they overturned what the boss wanted to do. And again, the Supreme Court, the way it is structured, I don't think that they're going to make a change. Let's make a shift here, because we could talk a while on this case. Maybe we'll find out it's an anomaly. Right. But workers' comp fraud does exist, Joe Gill, because you have the tapes.
Well, that's true. And there's one thing that we do before we even start the surveillance. And the first thing is we discreetly confirm that they live at the provided address. Second thing we do is we get a list of all vehicles registered there so we can see the position and the direction of those vehicles on the roadway. And the third thing we do is a social networking check. By that I mean, a lot of times we have the height and weight off the medicals of the claimant, but we don't really have a recent photograph off of Facebook or MySpace or whatever social networking site you want to mention. Sometimes that allows us to get a recent photograph. Also, it allows us to see what he's done in the past, but investigatively speaking, more importantly to us, what he's going to do in the future.
Well, Joe, give us an example. What do you see out there? I mean, again, there are scores of examples on YouTube or Google. I mean, we've seen hundreds of them, literally. But give us an example of what you've seen lately where you were asked by the insurance company to go out and investigate.
Lately, 3 days ago, we were asked to go out and put an individual under surveillance who is a known bowler, 63 years of age. He's an admitted bowler. What we did is we found out where the leagues were. I personally went out and observed and videotaped that individual for approximately 2 hours bowling. Now, again, my job is not to act as judge and jury, but I turn it over to defense counsel, who passes it on to the doctors to determine what we see here. Is it consistent or is it inconsistent with his claim?
Let's take a quick look, and this statistic we want to give you, where this graphic comes from the Coalition Against Insurance Fraud. And here are the 3 pillars of workers' compensation fraud according to them: fake or bogus injuries, Number 2, and pay attention to this category, employer scams, you read that right, and medical fraud rings, which could be lawyers and doctors and chiropractors, getting together and ginning up a case that shouldn't be there. But once again, Lori, employer scams, one of the big three there. So we've heard about the fake injuries. We hear about lawyers and doctors and chiropractors conspiring.
Right.
What people don't hear about are employers that don't pay workers' compensation insurance, that misclassify their employees maybe as independent contractors, that say, oh, well, they have a desk job, but they're really out working roofs. So in your practice, maybe that you don't see a whole lot of that.
No, I don't.
But it's out there, and it's happening.
Let me tell you when I think this happens. You don't see it with the large companies, the large employers. You see it with the smaller employers. I had a situation where I did have to represent a sole practitioner. So he's a contractor, and I had to represent him because he was told by the Bureau, and he does construction work, that he could hire people as independent contractors. And that's what he did. He hired a guy for his expertise in construction. That guy was hurt, that gentleman was hurt, and he went after the gentleman that I represented, the sole practitioner, the lone construction worker. He said he wasn't trying to fraud. He wasn't intentionally trying to fraud. He said, I called the Bureau, and they told me that I can hire this guy as an independent contractor. And so I find that situation where there may be no workers' compensation that the employee didn't. It's in those small companies and where they don't know.
And
they haven't been educated.
Or they're bidding for jobs,
Right.
and all of a sudden they're just trying to save some money on insurance. Let's roll in a clip here from Matt Wynn, who again, is much like Lori, is a respondents counsel, because I think some of these matters are nuanced, and then we're going to go to you, Judge, right after this. Let's hear from Matt first.
Sometimes employees are motivated to not come back to work, and they will exaggerate their symptoms. I mean, it's very hard for anybody to know how much pain a person is having, but if the MRIs and the X-rays are negative, it becomes a credibility situation. Who do you believe?
Judge, that's where you come in, because a lot of these so-called fraud cases may be a little bit more nuanced, as I said a moment ago. It really comes down to a matter of credibility.
Sure, and sometimes it's very hard to determine whether pain is real. We try to look at objective things such as the MRIs or medical issues. We try to look at claimant's work history. Is this somebody that's worked for a long time? Does this make sense? But ultimately, it is a human decision as to whether we believe the claimant is credible. And sometimes it comes down to the burden of proof. The employer may be trying to prove kind of an all or nothing that the claimant's fully recovered. And the claimant, if they don't win that petition, the claimant remains even if the claimant can do some work, the claimant continues to receive workers' compensation. So it's not like Social Security disability or Social Security where you have a 9-month period where you can try to go back to work at a light-duty job and you can go back out on Social Security if that doesn't work out. Workers' compensation, there is no such thing as kind of a trial period for work. So sometimes it is all or nothing, and it kind of comes down to the burden of proof and which party has that burden.
And Judge, sometimes video is going to make it into your courtroom, but it's not always dispositive, correct? I think a lot of people say, well, there's workers' compensation fraud video. Once that gets in front of a judge, done deal, ball game. Not always the case, right?
Absolutely, because what we're looking at is what is the employer trying to prove? If, for instance, the claimant's caught bowling, well, was the injury a rotator cuff injury and the claimant's saying they can't even lift their arm, or is this a construction worker or somebody that had carpal tunnel or something like that? So a lot of it comes down to what is the injury and also what is the pre-injury job. If it's a very heavy-duty job, to be honest, most of the surveillance we see is not dramatic surveillance where we have somebody chopping wood or on a roof or something like that. We get that very occasionally, but we generally see people doing their normal activities of going out of the house and maybe going to the grocery store, that sort of thing. And that does not necessarily prove that the claimant can go back to their pre-injury job.
Right.
And I think it comes down to a credibility issue. I think it all hinges on credibility. The insurance company, through their investigator, I've never seen Mr. Gill's work before. He sounds quite competent. I've never had to cross-examine him. But you're looking at credibility. Why do they put that evidence in? To prove that the claimant's a liar. So when I'm representing a claimant and their surveillance, I look at two things. Can my client, testify to this in a way that's consistent. You know, I tell my clients, you don't lie, you get up there and tell the truth. So if you went to the grocery store and you carried some toilet paper in one bag, you admit to that. I had a surveillance case one time where my client was 50, her mother was 80. They get them coming out of the supermarket with the cart, and the drama unfolds as they approach the trunk of the car. And they get there, and the 50-year-old reaches over and she unlocks the trunk and lifts the lid, and she turns to her 80-year-old mother, and the 80-year-old mother picks each bag up and puts it in the trunk because my 50-year-old client had a really bad back. I played that video. That helped me. I've had similar situations where the video helps us. But you got to go back to the core of the thing and say, what are they trying to prove? And if my client tells the truth, the fact that this guy was bowling, that's not going to ruin his case. If he comes in and he says, I have never bowled ever since I got hurt, then I think Judge Sheehan's going to say, I can't believe this guy.
And Joe, once you get video, and let's say your client is an insurance company, they ask for that video, that's in evidence, right? I mean, let's face it, if they're going to use it for any reason whatsoever, you've got to divulge to the claimant whether that video is good or bad for your insurance company client.
Chris, if I could take a step back and just address what George has said.
All right, go ahead.
He's right. But the bottom line, investigatively speaking, all we're trying to accomplish is get the subject on tape as much as possible. When we're videotaping someone, we're not thinking, boy, this is great, or maybe this is mediocre, or maybe it's the normal activities that someone does during the course of a work day, or a business day, or a weekend day. Our job is get them on tape so the medical people can say yay or nay to the claim.
Sure, you don't have a horse in the race.
I don't. And as a matter of fact, if we get no results, we may lose a client, but we still get paid the same amount of money.
Right.
So we're not a gun for hire in that regard.
I don't think they have a horse, but I want to ask, this is what I look for when I ask for surveillance, and the judge can let me know if it's good or not. Sometimes I'm not going to get a person who's a construction worker. I'm not going to get him lifting, you know, a 60-pound tire or lifting any heavy equipment. But that worker might be in comp before the judge saying, well, I can't walk but a block, and when I bend, I can't bend because I'm in so much pain, I'm in constant pain. So if I get a videotape of him, surveillance of him, showing that he can bend with no problem when he's not in court. He can bend with no problem when he's not before a doctor.
That's wonderful. That's a beautiful thing.
Does it work? I think it should work.
Of course it does, but here's my question. It hasn't been answered by Joe or you yet, and that is, once you have that tape, don't you have to turn that over and disgorge it and give it to the claimant?
You have to do it very quickly. I have clients, I say, if you have surveillance, you have to, when I know about it or when the employer or the claims representative knows about it, they have 15 days to get it to the claimant. And so once I know about it, I say, you've got to hurry up and give me this tape, because if I'm not in that window and the attorney on the claimant's side is smart, he can object to it, and it won't be admitted.
And also, if I could just interject for a second, even if the person shows no signs of distress or discomfort, has no apparent limitations, granted, hasn't done anything remarkable, how do we know that that same person isn't going to walk into the courtroom with a walker or some kind of cervical collar or whatever the case may be? Sometimes just getting him on tape as much as possible, even if it's not strenuous or athletic, could prove to help us at the time of trial.
Sometimes the investigators do get overzealous. I had one case where my client was the mother of the bride. She had a really bad ankle fracture and was unable to walk very well. And they still went after her, and they showed up at her daughter's wedding with a concealed camera. They lied their way into the wedding reception, and they took video, and the video showed that the whole bridal party walked down this long staircase except for the mother of the bride. So that helped our case. But I also think, you know, and this may be a little outside the area, but Facebook, for example. I tell my clients, you know, if you put up on Facebook, hey, we had a great time on vacation and we went skiing. Well, did you go skiing? Well, no, I can't. Well, you got to be careful what you say on Facebook, because Lori will be all over that.
I certainly am. I've done some really great things on Facebook.
She does her job. You know, someone raised an issue before, and I think it was the judge, and it was about not being able to go back to work and give it a try again. Let me roll in something here from Christian Petrucci, who's a claimant's attorney, and then Judge will throw it to you. Go ahead, roll it.
If you're on Social Security disability and you want to try going back to work, they'll let you return to work for up to 9 months and come out of work no questions asked, go right back on Social Security disability. Workers' comp in Pennsylvania has a 20-day trial period, if you even call it that.
Judge, what about that? I mean, Social Security disability, you've got all these months, but workers' compensation, people should know they got 20 days to give it a shot, and if not, they have to make a decision.
And that's really, I think the 20 days is coming from when the initial injury happens and whether the employer is going to accept it and whether the claimant's going to go out for injury. And that is the difference in workers' compensation. Sometimes it's kind of an all or nothing game in terms of the claimant going out on workers' compensation. And the once the claimant's on workers' compensation, it's very difficult sometimes for the employer to get the claimant off of workers' compensation in terms of burdens of proof. Getting the claimant back to work, they have to send out a notice that the claimant is cleared to return to work. They have to offer the claimant a light-duty job if one exists within that company. So there's all kinds of hurdles the employer has to go through, even to prove that the claimant can work. And then there's certainly another hurdle to prove that the claimant's fully recovered. So sometimes, as a judge, I have a case where I'm determining whether the claimant's fully recovered or whether the claimant is not. And I'm thinking, well, certainly the claimant could work and do light duty, but that's not before me. The only thing that's before me is whether the claimant's fully recovered. So the claimant might win that case, but really maybe the truth lied somewhere in the middle or the facts lied somewhere in the middle, and it was not the decision that I had to make or should make.
George, a comment from you, and then we're going to get right to your phone calls.
I've had situations where my client worked somewhere for a long time, values his or her relationship with the employer, and wants to give it a shot. When you have a smart defense attorney and a smart insurance carrier, and I say, look, he wants to give it a shot. Let's go for 30 days. Let's go for 60 days. And if he can't cut it, you're not going to stop his benefits. I've had situations like that. It's unusual because usually you have these robot-type insurance adjusters who just see a bottom line and bang, they're on them right away. And I think what Mr. Petrucci was talking about was also you could go back to work, they could file a suspension, but if you go out within 20 days, then it's a challenge petition. That could also be where they were going with it.
Got it. Okay, let's get to your phone calls. 1-800-426-4625. We're going to take them till the end of our half hour tonight and maybe for a little while thereafter. Christine from Doylestown, you're up first tonight. What's your question for us?
Hi, I'm an office worker, and my coworkers and I often go in together and buy sandwiches from a local sandwich shop. My boss asked me to go pick up the sandwiches, and I went to go get everybody's food. I got injured. I slipped and fell. I've been out of work for a couple of days. I feel like it's a workers' comp claim because my boss told me to go do it. It wasn't something that I did on my own. However, he's saying that it's not. Do I have a claim or no?
Well, I think it depends on how long you're out. You know, if you're only out for a couple of days and if things are okay and it's not a problem, well, then it's not worth it. But I mean, if you had suffered a severe injury, I think clearly if your employer says go pick up those sandwiches for your coworkers and you get hurt, I'll make a very good, strong argument for you if we ever had to file a claim. I don't know if the judge wants to weigh in on that, whether it's a declaratory statement or not.
Well, I think that the black letter law would be generally if you go off the premises and you're on break, that's generally not covered. But if you're directed by your employer, your boss, to do something during your break, that can be covered. So that would be the question if this case came to court is, was the employee directed by the employer to do a certain thing during the break, and that was what was being done during the break when the claimant was injured.
And she certainly would be eligible for any kind of medical benefits there, correct, Judge?
Yes, so and workers' compensation benefits under Pennsylvania, you're entitled to medical benefits day one, hour one, when you're injured. The question is whether you're out for more than 7 days. If you're out for more than 7 days, then you start being able to receive wage loss benefits or indemnity benefits.
Let's go to an email question that comes from, I think it's Dave. Can you be denied workers' compensation benefits if you fail the drug test 2 weeks after you were injured on the job? Does that make sense?
Well, there's not enough facts in that question.
Okay.
I mean, is the person still out of work, or did they go right back to work? Be denied what? So I think the question's really incomplete.
If he was injured and then he went back to work, but he was getting medical treatment, but then they have a regular drug test, and the employee underwent the drug test and failed the drug test, maybe in that situation he could be terminated for failing that drug test because his termination had nothing to do with his work injury. But just like George was saying, though, I mean, you really need to know more about the facts.
I had a case just like that once, actually, where the person was fired later after the work injury, but he was fired while on light duty. And we won because he was on light duty when he got fired, and they couldn't prove that his drug use was intentional. He ate a brownie at a party and he didn't know that it had marijuana in it, and that they couldn't prove the intentional conduct, so we won the case.
He said he didn't know they had, and we couldn't prove, the employer couldn't prove that.
You're suspicious right from the start, Laurie.
He knows he's going to get
Go ahead,
drug tested,
Judge.
so
I
he
think
went-
the judge was a joke. Go ahead.
Quickly, in that case, the employer generally has a burden to show there was available work. So, but for that they had a policy that if you fail a drug test, you are terminated, and but for the failing of the drug test, they had available work, and now the claimant's not doing that work because of failing the drug test. So there's kind of that additional burden. But under the case law, there are some cases that have held an employee that has failed a drug test where the employer had a policy and they had available work, but for the failing of the drug test, they can basically deny wage loss benefits. They would still be responsible for medical benefits, but not wage loss benefits.
Got it. I'm going to get a quick email question in here, and keep calling, folks, because we're going to stay in the studio for about 15 minutes. I want to quit my job, and my workers' compensation case is still pending with no settlement in sight. How will quitting affect the case? Quick, George.
Well, I mean, is the person still on benefits or not? Are they getting benefits? Are they getting partial benefits? There's too many facts, too many moving parts to be able to answer that kind of a question in this context.
Gotcha. I understand.
I see it, if I can hurry up, I see it as I'm working, I'm still in pain, or I think I'm in pain and I don't want to work anymore. Can I quit and while my case is pending?
How you quit is important.
Workers' compensation is marking a big birthday, but reports by NPR and ProPublica suggest injured workers may have less and less to celebrate. Good evening, I'm Christopher Naughton, and welcome to ALJ. And yes, workers' compensation is celebrating its 100th birthday this year. But what would the founder of the American comp system say about it today? The Legal's Gina Passarella has this.
As a people, we cannot afford to let any group of citizens or any individual citizen live or labor under conditions which are injurious to the common welfare. Industry, therefore, must submit to such public regulation as will make it a means of life and health, not of death or inefficiency.
In 1908, President Teddy Roosevelt called on Congress to protect workers and their families from injury on the job. Less than a decade later, the Grand Bargain became law in most of the land.
The Grand Bargain allowed the injured worker to recover even though he might have been at fault or she might have been at fault for their injury, but in exchange they gave up the right to sue their employer.
If you are giving up your right to sue the employer in exchange for obtaining workers' compensation benefits, then yes, it's a good bargain so long as you can get those benefits and so long as those benefits are adequate.
But let's see what's happened. Injured workers still don't have to prove negligence in order to be eligible for benefits. That's a good thing.
We haven't lost it. Still the Grand Bargain is alive and kicking in PA.
So all in all, it's been a good 100 years.
Workers' comp was born 100 years ago in this country. The laws are weak. They have to be reformed. They have been weakened in state after state.
And according to recent ProPublica and NPR investigations, injured workers today may have plenty to worry about.
There is a cyclical feel to it, but it has felt that there's been a general diminishment of the benefits for the injured worker.
As of late, there's been a shift towards a more conservative panel of judges who have disallowed or reduced or modified benefits.
So if it continues to go in a direction where the rights of the injured workers are reduced, and that's been the trend, then at some point those rights are not going to be sufficient and the bargain no longer makes sense.
Of course, lawyers for companies and insurance carriers see it differently.
No, I disagree. To me, I believe the court system is becoming more balanced. 25 years ago, I thought practicing workers' comp was almost like Wild Wild West. There really weren't any protections for the employer.
But even injured workers' lawyers and insurance companies may agree on one thing. Trends in some states are disturbing. Dallas lawyer Bill Minnick is leading a charge to get states to let corporations opt out of workers' comp and set up their own private benefits plan.
I think that that's putting the fox in charge of the hen house. States want to say we're more business friendly, come to us. And there's a race to the bottom.
You're going from one extreme to an employee-dominated system to another extreme.
I've had that conversation with clients relevant to the states where opt-out is an option, and although I'm not barred in those states, the clients and I have agreed that that's not an option for them, not right now.
In the end, this may be a passing phase in workers' comp's storied history.
Is it perfect? No. Does it get better with time? Yes. Was it revolutionary when it was put in place? Absolutely. It does get better and better, and there's always need for some adjustment.
The grand bargain. It's been around for 100 years. Are we just in the middle of one of its many cycles, or is the system trending away from paying employees their benefits? Lawyers for the employers would say this isn't meant to be a retirement system, but rather something to help employees get back up on their feet. But plaintiffs' attorneys and others are growing louder in their calls that this system is moving away from its humanitarian ideals in a race to the bottom. For the American Law Journal, I'm Gina Passarella.
All right, 3 guests with me this evening. Let's go ahead and meet them. Anthony Salvino is on the set once again, respondent's attorney, as we like to say in workers' compensation, with White and Williams. The Honorable Joseph Haken graces us with his presence once again, decades on the bench, a workers' compensation judge who has also authored a number of treatises that teach other lawyers and judges how to practice in this area. And George Beatty, who is an advocate and a champion for individual workers, those who have been harmed at the workplace and those who have been harmed by personal injury, medical malpractice, products liability, and the like. George ran for Congress, believing very strongly in benefits for workers back in 2012. And Senator Bob Casey was going to be with us tonight. Unfortunately, he will not be able to make it this evening. Senate was called into session today at 3 p.m. And given some of the events that happened over the weekend, we can understand why, but they're taking a rain check. We will see him sometime in the future. We will take your telephone calls tonight, folks. 1-800-426-4625. You've got a question on what we're talking about tonight, which is workers' comp. Is there a diminishing of workers' rights? You can ask us a question or comment, or if you've got a question about your own comp matter, chime in. So, again, this ProPublica NPR story, investigations, which is actually taking place throughout the year, has caused a bit of a shockwave throughout the practice that you folks are involved in. Let's take a look. 33 states, according to this report, apparently have been diminishing some of those rights. The 30 states have actually cut benefits or made it harder to qualify since 2002. I don't know. The report made it sound a little bit like the sky is falling. Is the sky falling here? Are workers really looking at a diminishing of benefits and maybe going back? Are we going back to the industrial age? Are we going back to pre-Teddy Roosevelt, or is that just hyperbole?
I'm hoping that the pendulum has swung as far as it's going to swing against workers, because it has been swinging against workers. I'm hoping it's going to start coming back the other way. We had a really good result in this year's Supreme Court election. Pro-worker Supreme Court justices were elected.
Pennsylvania, you're talking about.
In Pennsylvania, yes. I'm talking about Pennsylvania because I know in other areas of the country it's even worse. Mm-hmm. But we do need protections for workers. They've given up their right to sue. They should be taken care of. The law, as originally enacted, said it must be interpreted as a humanitarian and remedial statute. Ask Tony, we use those in our briefs all the time. And unfortunately, sometimes the reality is much harsher.
And obviously I disagree, Chris, but I find that it's become more balanced in the last 20 years. And to follow up on Lori's point, I actually believe it's fairer, it's more balanced, and the injured worker might have a good case, they might not. And now we leave it to the judge in a system that can obviously benefit the injured worker or obviously benefit the employer. And that's what I look at, and I believe it is becoming fairer and balancer.
Yeah, and Judge, to be fair, again, we're talking the ProPublica and NPR articles were across the nation, and again, only 17 states have made workers' comp laws better for their workers or kept it about the same. But to be honest here, at least in your state of Pennsylvania, there were some changes in the mid-90s, but I've even heard some claimants' attorneys say, you know, by and large, they're pretty fair for workers, and they've stayed on an even keel these last 15 to 20 years.
Yeah, I would agree with that. I think it's been on a essentially even keel. There have been some changes made starting in 1996, for example, where there are a number of offsets that the employer is entitled to. like Social Security, pension benefits, severance benefits. There's been some changes in regard to what they call impairment ratings, that after 104 weeks, if you're not 50% permanently disabled, you get into a partial status.
Right.
So there's been some restriction, but essentially I think it's working pretty good for the most part. Nothing like that report from NPR, I think it was also that reported,
yes,
insofar as Texas and Oklahoma is concerned.
Right, and we're going to get to that because that opt-out is a whole different animal. We might actually find that trial lawyers and defense lawyers, judges, insurance companies may all join in on that. But what is interesting is that, often, Tony, some clients of yours might say, well, I've got the option of moving to another state because costs are better in another state. Or I've heard some corporations say, well, costs have been going up. Let's actually take a look at costs nationally and in the state of Pennsylvania. Nationally, if you take a look at these numbers, they've actually gone down about $1.79. And if we compare that to Pennsylvania, you'll see that they've actually gone down further. So costs for corporations, for workers' compensation, have gone down over the last 13 years. So that really wouldn't be a valid argument, would it?
Well, I think you have to look at it in the spectrum, Chris. I think you have to look at it in the spectrum, and when you look at it, I think the cost before the enactment of the reforms that the judge was talking about in '96, costs were skyrocketing at much greater rates than they've gone down. I think that they have stabilized. I think the reforms have worked, and like I keep saying, made it more balanced and fairer. George obviously is going to disagree with me on that issue, but I think that the costs have stabilized, and I think also when you look at the economy rate of inflation hasn't gone up, so I think that's more a factor of that as opposed just to injured workers not getting their due day in court.
I think we're talking about this in an antiseptic, cerebral, intellectual way, but as a matter of reality, and an injured worker, he needs or she needs her income to pay the mortgage or the rent, to put food on the table for the kids. So when we talk about, well, there's been a reduction in costs for employers, that translates into less money on the, for working families who have suffered a bad injury. Some of the things that are terrible about these so-called reforms, the IRE process, the most horribly injured people who don't quite make it to 50%, didn't have both legs chopped off, will be cut off after 500 weeks. So if a person in their late 20s or early 30s suffers a devastating, disabling injury, if they're not more than 50% whole body impaired, if they didn't have both legs chopped off, their benefits are going to end when they're in their 30s. Sure, it's going to save corporations money, but what about that poor victim and his or her family?
And it's not even as bad as Texas and Oklahoma, which again we're going to get to in just a few minutes. And you talk about losing a limb. Let's actually take a look at what happens if you lose a limb. Now, in Georgia, this gentleman, Mr. Potter, lost his left arm in an industrial accident. He received, or will receive over a period of time, $740,000 for that arm. 50 miles away in the state of Alabama, you have a gentleman named Mr. Lewis. He loses a left arm from the elbow down. He only receives $45,000. That's pretty much, Judge, I just got to look at that and say, well, those are the laws of the states, correct?
That's right.
And so one state values an arm, and George might say it's not enough, and Tony might say it's just fine, but I think everyone here on the panel tonight would say $45,000 for an arm is appalling.
Right. Well, that's something that possibly the legislature could look at, but each state, of course, workers' compensation has been traditionally state-oriented. Each state has its own laws, so New Jersey is different than Pennsylvania. Delaware's different than New Jersey.
And maybe if Senator Casey were here tonight, he might say that's where we have to make some changes. Maybe we need some federal oversight because if there's that much of a difference, isn't that going to treat some people in some states in an exceedingly harmful fashion, and other people will be treated well?
Well, that certainly is something to be considered. Another factor in regard to that, though, is that if you become federally oriented, it may, as the states are doing a pretty good job, you may lower the benefits overall if you balance it out. If one state is really low and another state is really doing pretty good, the median may not be as good in some states.
Well, and here on the screen we actually have, again, this is from the NPR ProPublica article, what a hand or a foot or an arm might be worth in different states or by different corporations. So, for example, if you were working for Home Depot and you lose an arm, you could actually garner up to $1 million over your lifetime.
Well, not in
Because
Pennsylvania.
Not in Pennsylvania. Oh, I understand.
Yeah.
Oh, okay.
No, I can explain. I
Go ahead, please do.
In Pennsylvania, for example, we have a specific law statute, and I could go through it very quickly. A thumb is worth 100 weeks of benefits. Index finger, 50 weeks. Middle finger, 40 weeks. Ring finger, 30 weeks. Pinky, 28 weeks.
How much money?
So what matters is if somebody's making a whole lot of money, their maximum comp rate is $900 some a week. So the best you're going to do is $900 times 100 weeks. Is your thumb worth 100 weeks, even at $900? But what if the person's a low wage earner, really low wage earner, and they lose their thumb gets chopped off? You know, that's 100 weeks at a low rate. Your whole hand is 335 weeks. Your forearm is, if you lose it up to here, if it gets cut off right here, it's 340 weeks.
I understand that, George, but I understand it depends on how much money you're making. But give us some figures, if you will. Let's say the person's making $50,000 a year, so it's $1,000 a week, more or less. Are we talking about...
That wouldn't be their comp rate, though. If they're making $52,000 a year, their comp rate would only be $660 a
Because
week.
again, workers' comp gives you 2/3 of your salary as the benefit. And this is part of the grand bargain. You don't get your entire salary, but you do get 2/3.
And I did misspeak. 335 weeks for a whole hand, 370 for the forearm. And if you lose your whole arm up to your shoulder, you get 410 weeks of benefits. So that's the specific loss. And, you know, part of the issues in these cases, as Tony will say, is when you have a person that has a severe loss of use, it's not just getting it cut off. If you lose the use of it, that you can't use it for all practical intents and purposes, you could also get those benefits. But we always need to prove, as Tony will tell you, that the injury extended beyond that body part so that you don't have a credit. There's all kinds of ways for the corporations and the insurance companies to get over on the injured
Well, those
worker.
two gentlemen you saw up on the screen a moment ago from Alabama and Georgia, I mean, in one state, they actually put a prosthesis on his hand. In the other state, they only put a hook on his hand. He said, I didn't lose a hook. I lost a hand. So could something like that, could something like that happen here in Pennsylvania?
I would hope not. I mean, Pennsylvania does try to provide, and the employer is responsible for all cause-related, reasonable, and necessary medical expenses. And of course, you get into fights with it, but certainly where it comes to the hand, some sort of a prosthesis, I don't think that would happen in Pennsylvania, frankly.
Well, I've got something that actually is going to be refreshing for all three of us here on this part of the set, and probably for you as well, Judge. I'm actually going to get probably some agreement from respondents and claimants counsel right here on the set tonight. Now, Pennsylvania is not in the same boat as some of these other states, but there's a movement in Texas and in Oklahoma. You saw it in Gina's package just a few moments ago. South Carolina and Tennessee, they're actually offering corporations the ability to opt out and basically write their own rules. So the question goes back to, does that sound like we're going back to the industrial age or the pre-industrial age, so that we actually literally have corporations writing the rules, determining how much money people will actually receive, where the state laws have very little oversight, where if you don't report the injury within 24 hours of your shift, or Judge, I've actually heard on the shift itself, you may not be able to get workers' compensation benefits in those states.
Yeah, well, what I read about some of the things that they're doing, again, this is not Pennsylvania, where...
Or New Jersey.
Or New Jersey, or Delaware too, as I understand it, that the employers would be writing their own workers' compensation laws. So you might have 10,000 different workers' compensation laws, all made by an individual employer. That's not Pennsylvania. You have to have some uniformity. You're talking about there's lack of uniformity among the states. That's true, but each state is sovereign in this area. But if you're going to do it within the state itself or within the city itself, you can't have one employee getting a certain amount for a specific loss, a loss of an arm or a leg, and then down the block, another employee's not getting anything, perhaps, or much more limited amount of money. So that I just don't see that occurring in Pennsylvania.
Well, we've actually got a phone call on that very issue. Hillary is calling from Philadelphia tonight. Hillary, what's on your mind?
Hi. I just started my claim here in Pennsylvania, and I'm worried about all these changes. Is Pennsylvania different than other states, and is there a grace period?
Interesting, too. And I thought actually her question was about could some of these changes take place here in Pennsylvania that we're seeing in Texas and in Oklahoma, but let's see if we can address her question.
These cases are all very, very fact specific. So when you're talking about a grace period, we need to know when was the injury, was it reported right away? You have reporting requirements, you're supposed to tell your supervisor about it right away. There are certain time limitations. I mean, it's the kind of a thing where it's hard to answer a question that's so broad without more facts, so it's not really conducive to a TV kind of call.
Okay, but at the same time, I mean, there are some time limits in Pennsylvania. Maybe it's not 24 hours to report
There's
the injury.
21 days. You
21
need to report
days,
the injury within 21 days to your
Okay.
supervisor, and if you don't, then you won't get benefits from the beginning. If you don't report it within 120 days, you can be barred from ever making a claim.
All
And
right.
then there's a 3-year statute of limitations for actually filing the claim petition. But I mean, I think the comp law is full of traps for the unwary, and if a person's hurt at work, they really should get a lawyer right away.
Right. Okay, but a lot better than 24 hours, Tony.
Oh, absolutely. And that, just to bring it back with the opting out, it just seems like it's not going to work. I mean, if you have different states or different entities with different rules, I mean, at least with the Compact as we have it now, it's uniformity, as George just said, you have 121 days to report it. If you don't, then there's a defense. You have 3 years to bring the claim. So I'm not a big proponent of opting out of the states because I think it's going to be unruly.
You were prophetic as well.
Yeah,
I
and-
mean, Tony and I, we're singing Kumbaya.
I'm actually going to hug him. Yeah.
We're singing, we agree because
Well,
the insurance companies
yeah.
who Tony represents, they don't want people going outside the system writing their own laws. They want big companies to buy insurance from them.
Yes.
And so do I.
Right, there you go. And Judge, actually, just to make it clear, here in Pennsylvania, you actually could opt out. A company could opt out if they really wanted to, but you've never heard of it.
Well, you could actually opt out under a collective bargaining agreement that if an employer has a collective bargaining agreement, the union and the employer could enter into some phases of workers' compensation and procedures. However, the Pennsylvania Act specifically says this is supplemental to workers' compensation, so it could never be limited. It could never be less than what you would get under workers' compensation Pennsylvania law.
Right.
But I haven't seen any cases in regard to that where that's been employed.
Let's get to some of the telephone calls. I've got more questions here, but so do you. Nathan, you are up next tonight. What's your question for us tonight?
My question is I was injured on the job back in February. My claim was accepted, and it's been open since. And I have now been ruled permanently disabled. What's my options going forward, and what do I need to do to continue to receive benefits?
That sounds like an unusual situation, frankly, when you say you've been found permanently disabled. Was this a state workers' compensation situation, or did you work for the federal government?
It was a state case.
Who was
your for an employer?
Was it the federal government was your employer?
No, it was a regular employer that I was injured on the job.
Well, because when you say permanent, there's really no categorization like that for a permanent injury. Usually it's temporary total disability, it's called. So I think, again, this is one of these things that's fact sensitive.
Right, but if someone has total disability, if somehow they've been adjudicated or it's been determined maybe by a doctor.
It would be temporary total. Temporary total disability is the full boat of workers' comp, and it's by its very nature temporary total disability.
Right. Until there's a change in the condition.
Right.
Until there's a change in condition.
There's always a chance for them
but
to come
judges,
back.
and there's always a chance that someone could be receiving comp for the rest of their lives. That's not completely unheard of. It's unusual, but not unheard of, correct?
Right. You'd have to be able to show after 104 weeks of receiving total disability benefits, if your impairment rating is 50% or more, you could continue to get total disability benefits, and potentially that could be payable for a lifetime. But the 50% threshold is a pretty tough one to meet. That's true.
You know, I wanted to bring up something that I think the viewers should know about for sure. A case just came down from the Commonwealth Court this year, a few months ago, called Protz is the name of the case. And in that case, the Commonwealth Court struck down the portion of the IRE provisions in the Workers' Compact that apply to newer versions of the Guide to the Evaluation of Permanent
Make sure you
Impairment.
tell people what IRE is.
So an IRE is an impairment rating evaluation. So there are thousands and thousands of people in Pennsylvania who are on the clock. The clock is ticking down, and when they reach 500 weeks, their benefits stop. under this new case, if you file a petition with the workers' comp judge, whether it be Judge Haken, whomever, you can get that clock to stop. You can get your benefits reinstated and keep them coming, because perhaps, it's going to go to the Supreme Court, but I think that the days of the IRE in its present form are numbered, because the Commonwealth Court even struck it down.
So there you go, Tony. There's another bone for the worker in the state.
Well, that's exactly what I was going to say. I thought I was going to say to George, I thought the benefits were being reduced, but now they're actually being augmented in this case. And I have to give the claimants bar credit. I mean, the argument that they made in this case was brilliant. I mean, the state legislature, when they changed it, made it that the IRE physician was supposed to use the 4th edition of the guide to impairments, or the most current edition. And what the court said was that the legislature is actually administrating to an administrative judge legislative policy, and they threw out the section of the statute declared it unconstitutional. It was a brilliant argument. I think it's wrong.
Oh, I think it's 100% right. How could the legislature turn around and say, we're going to give these doctors in some office somewhere else in the country the power to legislate in Pennsylvania? They said, no, only the Pennsylvania legislature.
And some of that's what's taking place in Texas and Oklahoma. We're going to continue to take your phone calls, even if you don't get it in before 7:30 tonight. We'll stay in the studio for about another 15 minutes, so keep calling 1-800-426-4625. Let's go to David next. Go ahead, David. You're on the air.
Yes, hi. This is David from Allentown.
Go ahead. What's your question, David?
Yeah, it's my understanding that a company or a corporation has always been able to self-insure, to be their own insurer. I'm not clear on what the difference is between that and the so-called opting out. Could you explain?
A big difference. I mean, self-insuring is the company has enough assets to put aside, they hire a third-party administrator, and they administer their own benefits under the law. So they still have to follow all the same laws that the insurance companies have to follow. It's just that they're financing it themselves. It makes no difference, essentially, in terms of what law applies to that particular injured worker.
Yeah, and the opt-outs that we're talking about in Texas and Oklahoma, they're basically writing the laws for the state. So in essence, for any of those who opt out, they're basically getting folks to get those things passed in their legislature, and that means that you only get so many weeks. You may only get 2 years of, like someone called earlier and talked about some sort of permanent disability. In Texas, you might only get 2 years worth. You were going to say, Tony, I thought you were going to chime in.
No, I was just going to say that the self-insureds are heavily regulated by the state. They have to, as George said, comply with the law, the Pennsylvania law. So it's totally different.
It's like the employer being its own insurance company.
Right.
That's really what it boils down to. I did want to comment, though, with the unconstitutionality of the impairment ratings as declared by the Commonwealth Court, and hopefully the Supreme Court's going to be reviewing it, that in that situation, it was indicated that the legislature makes the law and not private individuals making the law. That might also apply to these opt-out provisions if it was ever done in Pennsylvania or attempted, because you'd be giving to the individual corporation the right to change the law, whereas that really is the obligation of the legislature to do that. So the same sort of arguments that were made in that case might be applied also to an opt-out situation.
That's why Judge Haken is so well respected, because you nailed it. I mean, we want to see this case upheld. We want to see this as precedent for future attempts to raid the system, because there's always a group of super conservative Republicans that are bought and paid for by big corporations that try to dilute the rights of workers to the benefit of the top 1% of income earners. So we need to have those protections. This case can be used later as precedent on one of those assaults. So I'm
quickly, Tony, because we're running out of time, but we don't see these opt-out provisions coming anywhere near to Pennsylvania or New Jersey at this moment.
I do not. No.
All right.